Hello, and welcome to today's presentation about title insurance for attorneys new to real estate. My name is Kevin Pogoda, and I have the pleasure of serving as the Virginia State Manager for the Northern Division for Old Republic National Title Insurance Company. I've been in the industry for about 25 years, 8 years as a settlement officer and title attorney, and 17 years in my current job at Old Republic, where Old Republic is the owner and the provider of title insurance for real estate closings. Now, I love what I do for a lot of reasons, but I'm going to limit myself to just two by way of introduction. The first thing I love about my job is the people. Real estate is essentially the same. The transaction of transferring title from one to another and insuring it, well, it's fundamentally the same. But the people, they're so different. And I've played a part in transactions with teenagers and octogenarians, with US citizens and with people from foreign nations, with people that have very little to spend and with people who have millions to spend. I love to travel, but I almost don't have to. It's almost as if the world comes to my job because everybody needs to live somewhere. And when that somewhere means purchasing real estate, well, that usually means title insurance, and that's what I do. Beyond the individual people for each transaction, there's a bigger picture, a really big picture. And that's the second thing that excites me about title insurance. When a transaction happens involving a loan, often that loan is sold, maybe more than once. And that selling of the loan is what creates the secondary mortgage market. There is an incredible amount of capital created in that process. Capital used for more buying and building and investing and creating even more capital. And there's a lot of factors that go into creating a robust US economy, but there cannot be a robust US economy without a robust real estate economy. And arguably, there cannot be a robust world economy without a robust US economy. So when you play a part in a real estate transaction, whatever that part may be, you are contributing to a process that arguably makes the world go round economically. And for me, that is exciting. And almost every one of those transactions involve title insurance. So let's talk about that. The practice of insuring title began after a Pennsylvania Supreme Court ruling in 1868 in the famous case of Watson versus Muirhead. I'm not going to go into all the details about the case, but the main takeaway is this. Someone there made a mistake in the transference of title, and the buyer suffered a loss. But because of the facts of that case, there was no one for the buyer to sue. As a result, in 1874, the Pennsylvania legislature passed an act allowing for the incorporation of title insurance companies. Thus, title insurance was born. Well, as you can well imagine, we've certainly come a long way since then. Today, title insurance is not a byproduct of any case law. It's statutory. Virginia Code Section 38.2-123 defines title insurance as insurance against loss by reason of liens and encumbrances upon property, defects in the title of the property, and other matters affecting the title of the property or the right to the use and enjoyment of property. Simply put, like other forms of insurance, title insurance is a contract to indemnify against actual loss. But that is where the similarity between title insurance and other forms of insurance ends. Other forms of insurance primarily involve risk assumption. For example, your premium for life insurance is influenced by your age, your gender, your medical history. If such factors present more risk for the insurer just increases the premium to account for the increased risk. But no corrections are made to these factors. You're not asked to quit smoking, for example, before getting life insurance. You're just going to pay more money in premium if you do. Same is true for car insurance, homeowners insurance, health insurance. It's all based on risk assumption. Title insurance is different in that it primarily involves risk elimination. Prior to issuing title insurance, a title agent will obtain a title search from a lay abstractor or a title opinion letter from an attorney so that the title agent can understand all the things that affect title and correct all revealed title defects before issuing a policy. Generally speaking, if such defects cannot be corrected, the title insurer will not charge a higher premium. The title insurer will simply refuse to issue the title policy. As title insurers, we don't insure known defects. We do not assume the risk. Seen in this light, title insurance in its purest form is insurance against the unknown. It's meant to cover the possibility of human error that did not come to light in the process of administrating the real estate transaction. As such human error could be committed by the abstractor who searches and reports the title, by the attorney who renders an opinion of title, by the title agent who administers the title insurance, or by the settlement agent who processes and closes the transaction. When one of these individuals makes a mistake that affects title, the injured party, typically the buyer, has two choices. If the buyer obtained a title insurance policy, the buyer can just file a claim by sending a letter to the title insurer. That's it. There's no additional cost involved. If the claim is covered, well, then the title insurer will make the insured whole by either fixing the problem or paying the insured an amount equal to the loss of value due to the title defect. If attorneys must be employed to accomplish this, well, the insurer pays. But without a title insurance policy, well, what's left to do? An injured party is left to pay for an attorney and pursue recovery based on warranties in the deed or breach of contract or theories of negligence or other legal bases. There's a number of problems with this approach worth highlighting. Problem number one is that it just might be cost prohibitive. It doesn't make economic sense to pay an attorney $20,000 to fix a $10,000 title problem. But let's assume that the title defect is much bigger. Problem number two is that a title defect caused by the type of human error I've been talking about may not be discovered until the property is sold again in another 5 or 10 years or more. At that time, another title search would be performed for that transaction, revealing the title defect that was missed in the prior transaction. Well, by that time, 5, 10 years or more, culpable parties might be out of business, dead, or otherwise hard to reach. So there might not be anyone left to sue. Now, problem number three, problem number three looks beyond human error. Here, it's important to realize that a consumer can experience actual loss to title, even when no one does anything wrong. And that's because our land record system, where all the deeds and mortgages and liens are recorded, that system is imperfect. Without going into the detail about all those imperfections, suffice it to say that those imperfections can create title defects and cause loss to the buyer. And if that happens, there really is no one to sue. You can't sue the land record system. Your only recourse is a title insurance policy. So, what does a title insurance policy cover? Title insurance policies come in a variety of flavors, policies for owners and policies for lenders. For owners, basic policy coverage is offered in something called the owner's policy, and more extended coverage is offered in something called the homeowner's policy. Now, don't confuse a homeowner's policy with homeowner's insurance. A homeowner's policy is a policy to indemnify against loss as it relates to title. Homeowner's insurance protects your physical dwelling against fire and other calamities. I can't explain why two different forms of insurance have essentially the same name, but I bring it to your attention so that you will not be confused. Regardless of the type of title insurance policy, and again, we're talking about the owner's policy or the homeowner's policy, both policies offer 4 core protections for the borrower, for the owner. And they can be easily represented by an acronym ONAM, O-N-A-M. So first, coverage is that you own it. O stands for own. In other words, whatever you contracted for in the sales contract, that's what you got. That's what you're insured for. If someone claims to have an interest in the real estate later, this policy coverage would apply here. And this also means that the estate that you contracted for is what you're insured for. And normally this means fee simple, the whole bundle of sticks, all the rights. So if you wound up with something less, like a life estate or a leasehold estate, your title policy would likely cover you based upon that coverage. Second coverage, N, no liens. This coverage is protecting that you have no liens or other defects to that title. And that's a big net, including protection against all sorts of encumbrances to title that attach to some prior owner on title. Unreleased mortgages, child support liens, IRS liens, judgments, and the list goes on and on. Third coverage, A, access, that you have access to the property. What good is a squeaky clean title if you can't get to it? At a minimum, this means legal access. In other words, the subject property touches a public right-of-way, or it benefits from some sort of access easement across one or more other properties, and that access easement reaches a public right-of-way. Final fourth coverage, M. Title is marketable. In other words, when you finally turn around and sell the property, no title issue arises that would keep a reasonable purchaser from going through with the transaction. But if that happens, this coverage would apply. That's the core coverage for owner's policy. Again, 4, own it. And there's many more coverages in the owner's policy, which is the standard coverage, and many, many more than that in the homeowner's policy, which is the enhanced coverage. But one more feature of the owner's policy is worth mentioning. For purchasers, buying a policy is optional. The optional nature of the owner's policy is disclosed to the consumer at a few points throughout the transaction, but at the very least, it is disclosed at settlement on the settlement statement that the purchaser signs. The CFPB, standing for Consumer Financial Protection Bureau, which regulates our industry, in the last several years created a settlement statement called the Closing Disclosure Statement, which is mandatory for most real estate transactions. And this settlement statement highlights the optional nature of title insurance for the purchaser. But if that purchaser gets a loan, title insurance for the lender is not optional. Lenders always require the purchaser to buy a loan policy to benefit the lender. That's a condition of the loan. For lenders, they want to make sure that if they have to foreclose, their sale to the highest bidder at auction will not be derailed by a title defect. And having the title insured for the lender allows the lender to sell the loan on the secondary mortgage market, creating all that wonderful capital I was talking about earlier and making the world go round. And with that brief introduction to me and to this world of title insurance, I'll now hand things over to Kay.